Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 2nd April 2025 and we bring you news that matters. The first news for today is as follows. The Supreme Court has issued a stern directive to the Directors General of Police DGPs across all states and union territories, emphasizing strict adherence to established arrest guidelines. The court warned that any deviation from these norms would result in stringent action against the responsible officers. This directive came during the hearing of a case where the petitioner alleged unlawful arrest and physical abuse by Haryana police in violation of the Supreme Court's guidelines set forth in the Anesh Kumar judgment. The petitioner claimed that his arrest was followed by physical assault both at the scene and later at the police station. The bench, comprising Justice Ahsanuddin Amanullah and Justice Prashant Kumar Mishra, expressed concern over the apparent high-handedness of police. They underscored that even individuals accused of crimes are entitled to certain rights and must be treated with dignity. The court stated, even if a person may be a criminal, the law requires that he be treated in accordance therewith. In light of these observations, the Supreme Court instructed the DGPs to circulate the Anesh Kumar judgment and related directives among all police officers and to ensure their strict implementation. The court emphasized that failure to comply would lead to severe consequences for the erring officials. Next news. The Na High Court has declined to stay a single judge's order that quashed the Enforcement Directorate (ED) summons to Dr. Naushad B. former Commissioner of the Mysore Urban Development Authority (MUDA). The summons pertained to an investigation into the alleged illegal allotment of land to Chief Minister Siddaramaia's wife Parvati during Dr. Natesha's tenure. A division bench comprising Chief Justice N.V. Anjaria and Justice K.V. Arvind ruled that while the stay on the single judge order was not granted, the investigation into other accused individuals could proceed. The court stated that the judgment is not in rem and should not hinder the ongoing investigation against other persons involved in the case. The ED is permitted to utilize all documents and materials gathered, including statements from Dr. Natesha, in accordance with the law. This decision follows an earlier ruling by a single judge, which invalidated the EDS's search and seizure at Dr. Natesha's residence and the subsequent statements recorded under Section 17(1)(f) or the Prevention of Money Laundering Act (PMLA), citing a lack of reason to believe. The single judge also quashed the summons issued under Section 50 of the Act. The ED had appealed this decision, arguing that the order adversely affected ongoing and future investigations. The High Court's recent ruling allows the ED to continue its probe against other accused individuals, ensuring that the investigation proceeds unhindered. Next news. Union Minister for Minority Affairs, Kiren Rijiju, has clarified that the Waqf Amendment Bill 2025 is prospective in nature and will not have any retrospective effect. Speaking in the Lok Sabha, Rijiju addressed concerns regarding the removal of the Waqf by user provision emphasizing that properties already registered as Waqf will remain unaffected. Rijiju stated that existing by user properties registered on or before the commencement of the Amendment Act will continue to hold their status, except for those properties currently under dispute with the government. He assured that the legislation does not aim to confiscate any properties belonging to religious sites, such as masjids or dargahs, but seeks to improve the management of Waqf properties. Highlighting changes in the bill, Rijiju pointed out the removal of Section 40 of the Waqf Act, which previously allowed the Waqf board to declare any property as Waqf land. He described this section as draconian, noting instances where properties belonging to Hindu temples, Sikh gurdwaras, Christian families, and farmers were declared as Waqf lands. The amendment also proposes the inclusion of non-Muslims in Waqf boards, with Rijiju arguing that since the board is a statutory authority managing properties, its composition should not be limited to Muslims alone. The Waqf Amendment Bill 2025 has sparked debates and concerns among various communities and political parties. Critics fear that the amendments could undermine the rights of the Muslim minority and potentially lead to the confiscation of historic properties. The government, however, maintains that the changes are intended to combat corruption and promote diversity within the management of Waqf properties. Next news: the Supreme Court has declared the Prayagraj Development Authority to pay 10 rupees lakh each in compensation to 6 individuals whose houses were illegally demolished, labeling the action as inhumane and illegal. The bench, comprising Justices Abhay S. Aukar and Ujjal Bhuyan, emphasized that the right to shelter is an integral part of Article 21 of the Constitution. They criticized the authorities for violating due process, noting that the demolition notices were improperly served by merely affixing them, which the court deemed insufficient. Justice Aukar remarked, "This shocks our conscience. There is something called the right to shelter, something called due process." The court's decision underscores the necessity for authorities to adhere strictly to legal procedures and respect constitutional rights when undertaking such actions. Next news: the Supreme Court has elucidated the distinctions between the provisions governing the registration of a First Information Report (FIR) under Section 154 of the Code of Criminal Procedure (CRPC) and Section 173 of the Bharatiya Nagarik Suraksha Sanhita (BNSS). While both sections are substantially similar regarding the recording of information, the court highlighted a significant departure introduced by Section 173(3) or the BNSS. Under Section 154(1) or the CRPC, any information relating to the commission or cognizable offense must be recorded by the officer in charge of a police station without conducting any preliminary inquiry. In contrast, Section 173(3) or the BNSS allows for a preliminary inquiry before registering an FIR for offenses punishable with imprisonment of 3 years or more but less than 7 years. This inquiry requires prior permission from a superior officer and aims to ascertain whether a prima facie case exists for proceeding with the matter. The bench, comprising Justices Abhay Aukar and Ujjal Bhuyan, made these observations while quashing an FIR registered by the Gujarat Police against Congress Rajya Sabha MP Imran Pratapgarhi. The case pertained to an Instagram post featuring a video clip with the poem Akhoon Ke Pyase Baat Suno. Next news: The Supreme Court has reaffirmed that under Section 319 of the Code of Criminal Procedure, CRPC, a trial court possesses the authority to summon additional accused based solely on the examination in chief of a witness, without necessitating the completion of cross-examination. This ruling emerged from a case where the trial court, citing prima facie involvement of the proposed accused based on the unrebutted testimony of the complainant, allowed an application under Section 319 CRPC. However, the High Court, upon reevaluating the evidence, overturned this decision. The Supreme Court, in turn, set aside the High Court's judgment, emphasizing that the trial court's discretion under Section 319 CRPC should not be interfered with unless clear illegality or perversity is demonstrated. Referring to the Constitution Bench decision in Hardeep Singh v. State of Punjab, 2014, 3 SCC 92, the Supreme Court highlighted that the standard for invoking Section 319 CRPC requires more than a prima facie case but less than full satisfaction that the evidence, if unrebutted, would lead to conviction. The court underscored that the term evidence in Section 319(1) CRPC encompasses evidence recorded during the trial, and the power to summon can be exercised even before cross-examination if the evidence suggests the involvement of the person in the offense. This judgment clarifies that trial courts can summon additional accused at any stage during the trial based on the examination in chief, ensuring that individuals who appear to be involved in the offense are brought within the ambit of the trial without undue delay. And the final news for today is as follows. The Supreme Court has reaffirmed that quasi-judicial bodies are bound by the principles of res judicata, which prevent the relitigation of issues that have been previously adjudicated and attained finality. This ruling came in response to a case where a quasi-judicial authority issued a second order on a matter already decided in an earlier unchallenged order. The Rajasthan High Court had upheld this second order, prompting an appeal to the Supreme Court. The bench, comprising Justices Vikram Nath and Prasanna B. Varal, observed that once an order by a competent authority is accepted by the parties and attains finality, the authority lacks jurisdiction to entertain a subsequent application that contradicts the original findings and directions. The court emphasized that the principle of res judicata applies equally to quasi-judicial bodies, citing the precedent set in Ujjambai v. State of UP, which established that findings by judicial or quasi-judicial tribunals are binding until reversed through appropriate appellate or revisional procedures. This judgment underscores the necessity for quasi-judicial authorities to adhere to the doctrine of res judicata, ensuring that matters conclusively settled are not reopened, thereby upholding the integrity and finality of judicial decisions. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.